According to federal law, if someone is convicted of a crime and punished with more than 1 year in jail, they lose their rights protected under the Second Amendment. A recent decision by the Ninth Circuit Court not only brought the federal law into question, but decided it was wrong. The court didn't find that this federal law violated the Constitution, rather they found it violated the Supreme Court's Bruin decision. Is that all this federal law violated? We'll discuss that next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
The question about the constitutionality of convicted felons losing their voting and gun rights for life comes up regularly here at the Constitution Study. In response, I point out what James Madison said. In a word, as a man is said to have a right to his property, he may be equally said to have a property in his rights. If our rights are our property, then they are protected under the Fifth Amendment's Due Process Clause. However, the Fifth Amendment doesn't say you cannot be deprived of the property you have in your rights, only that it has to be done by a due process. Now, if a person is charged, given a speedy and public trial by a jury of their peers, and convicted with due process, then the protections under that Fifth Amendment have been served. The problem I have is the way it is implemented, especially at the federal level. Let's start out by looking at the law and the question in this case. 18 U.S.C. Section 922 G1 makes it a crime for any person to possess a firearm if he has been convicted of an offense punishable by imprisonment for a term exceeding 1 year. As always, we need to look not only at the statute cited, but its context. For example, Section 922G states, "It shall be unlawful for any person who has been convicted in any court of a crime punishable by imprisonment for a term exceeding 1 year to ship or to transport in interstate or foreign commerce, or possess in or affect commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce." Let's break this down. First, a person described in subsection G, which includes a laundry list of prohibited possessors, is not allowed to ship or transport firearms or ammunition in interstate or foreign commerce. Now, this comes under the Commerce Clause in Article 1, Section 8, Clause 3, which reads, "Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes." Subsection G also prohibits those listed from possession in or affecting commerce any firearm or ammunition. This is a problem, since Congress is not authorized to regulate commerce in general, only interstate and foreign commerce. The restrictions go on. Or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. Neither is Congress authorized to regulate items which have been shipped through interstate or foreign commerce, only said commerce itself. This means that most of 18 U.S.C. 922G is unconstitutional and therefore void. The Supreme Court recognized this in several cases, including Ex parte Siebold, which states, "An unconstitutional law is void and is as no law. An offense created by it is not a crime. A conviction under it is not merely erroneous, but is illegal and void and cannot be a legal cause of imprisonment." Unfortunately, this is not what the Ninth Circuit panel found. Stephen Duarte, who has 5 prior nonviolent state criminal convictions, all punishable for more than a year, was charged and convicted under Section 922G1 after police saw him toss a handgun out of the window of a moving car. It doesn't sound like Mr. Duarte is a very nice man. 5 times he's been convicted of nonviolent crimes punishable by more than a year in prison. Now, like anyone else, though, Mr. Duarte's rights should be protected, and we, as a people, should do all we can to ensure that. Duarte now challenges the constitutionality of his conviction. He argues that, under the Supreme Court's recent decision in New York State Rifle and Pistol Association v. Bruin, Section 922G1 violates the Second Amendment as applied to him, a nonviolent offender who has served his time in prison and re-entered society. We agree. Notice, Mr. Duarte isn't challenging his conviction because it violates the Second, Fifth, and possibly the Eighth Amendments to the Constitution, but because it violates the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin, which says it violates the Second Amendment. Not surprisingly, the federal government disagrees with Mr. Duarte. We reject the government positions that our pre-Bruin decision in the United States v. I.O.T.C forecloses Duarte's Second Amendment challenge. I.O.T.C is clearly irreconcilable with Bruin and therefore no longer controls because I.O.T.C held that Section 922G1 comported with the Second Amendment without applying the mode of analysis that Bruin later established and now requires courts to perform. Again, the court doesn't find for Mr. Duarte because of what the Constitution says, but because of what the Supreme Court said. This may explain the dissenting opinion. Judge M. Smith dissented. He wrote that until an intervening higher authority that is clearly irreconcilable with I.O.T.C is handed down, a three-judge panel is bound by that decision. In Judge Smith's opinion, until the Supreme Court, the only real intervening higher authority in the judicial branch, says that Bruin or some other decision specifically overturns I.O.T.C, the court has to follow it. Apparently, his oath to support the Constitution of the United States isn't high enough an authority to intervene over their previous decision. Judge Smith did bring up a point I want to dig into deeper, though. Instead, Bruin reiterates that the Second Amendment right belongs only to law-abiding citizens. Duarte's Second Amendment challenge to 18 U.S.C. Section 922G1, as applied to nonviolent offenders, is therefore foreclosed. If someone is convicted of a crime, does that mean they are forever labeled as not a law-abiding citizen? Does a single conviction, even of a nonviolent crime, leave someone with the equivalent of the mark of Cain, forever labeled as a criminal? What about those who fulfill their debt to society? Does completing their sentence fulfill their debt? Are they forever held liable for their transgression of the law? I can see a rationale behind prohibiting those with violent felony convictions, especially multiple such convictions, from possessing firearms. But we still have issues with 922G, because 922G does not ban felons in possession, as many refer to it, but people who have been convicted of crimes punishable by more than a year in jail. I believe there are several states that have misdemeanors which can carry punishments of a year or more in jail. I do not believe the opinion of the court states whether or not Mr. Duarte's conviction were felonies or not, only that he was sentenced to more than a year in prison for each of them. Now, if we can agree that there are crimes and situations where the punishment should include the loss of certain rights, such as the right to the possession of firearms, what is the proper way to go about it? First of all, except for Washington, D.C. and the land purchased from the states, Congress does not have the authority to write general legislation for the nation. Congress does have the authority to regulate interstate and foreign commerce, but the attempt to bootstrap this legislation by claiming to regulate everything that passes through interstate or foreign commerce would be laughable if so many courts didn't follow along. If Congress can claim the power to regulate everything that passes through commerce, then they can regulate just about everything in our lives. This reminds me of the warning James Madison gave about the General Welfare Clause. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress, for every object I have mentioned would admit to the application of money and might be called, if Congress pleased, provision for the general welfare. If everything that passes through interstate or foreign commerce can be regulated by Congress, then everything you buy can be regulated through commerce. Even worse, since 922G doesn't simply claim to regulate commerce, but the rights of people to possess a product that passed through interstate commerce, at some point, it is pretty much everything we purchase in this day and age. So Congress does not have the authority to pass general legislation outside of legitimate federal land. Neither does it have the authority to regulate products, only interstate and foreign commerce. So it appears 922G is unconstitutional and therefore invalid. Now, there are more questions we should be asking. For example, when someone is sentenced, is that the limit of their punishment? Is it due process for Congress to impose a penalty via legislation beyond what is imposed by a judge? How can a law passed by Congress consider the circumstances in a specific case? When should someone be deprived of their rights as punishment for a crime? Should someone be shown to be a danger to society before government deprives them of their rights? Is the punishment of a permanent loss of rights cruel or unusual? Interestingly, later the same month, the Supreme Court decided another case involving the Armed Career Criminal Act, Brown versus United States. These cases concern the application of the Armed Career Criminal Act to state drug convictions that occurred before recent technical amendments to the federal drug schedule. This case revolves around the question of whether the conviction in state court of the two defendants, Justin Rashad Brown and Eugene Jackson, qualified as serious drug offenses. Now, in the case of a person who violates Section 922G of this title and has 3 previous convictions by any court referred to in Section 922G1 of this title for a violent felony or a serious drug offense, or both, committed on occasions different from one another, such person shall be fined under this title and imprisoned not less than 15 years, and notwithstanding any other provision of the law, the court shall not suspend the sentence of or grant probationary sentence to such person with respect to conviction under Section 922G. Now, the Supreme Court found as follows. Held, a state drug conviction counts as an ACCA predicate if it involves a drug on the federal schedules at the time of that conviction. Once again, we see the courts coming up with correct decisions for the wrong reasons. The Circuit Court didn't find that 922G violated the Constitution so much as it violated the Supreme Court's opinion in Bruin. It didn't even touch on the Fifth or Eighth Amendment issues. Don't get me wrong. I believe the court is correct in finding 922G unconstitutional. But I have to wonder what the unintended consequences of the rationale are going to be. I would not be surprised if this gets appealed to the Supreme Court, and who knows how they may decide the case. Speaking of the Supreme Court, since their decision was not based on the constitutionality of 922G, but whether the crimes committed by the two defendants rose to the level of serious drug offense under 924E1, I don't think there's enough information to speculate how the court might find. If the United States appeals the Ninth Circuit decision, I believe the court's decision will be influenced by the argument for Mr. Duarte. If his attorney continues with the Bruin-based defense, that might appeal to the judicial supremacy that the justices frequently exhibit. I wonder what would happen if the Fifth and Eighth Amendment issues were added to the argument. Since we don't have a crystal ball, we'll all have to wait and see if the case is appealed and accepted. So here's the question. Can you be deprived of your rights as punishment for a crime? And if so, under what conditions? I believe there are situations where the crime is serious enough as to warrant such a level of punishment, but I don't think it can be dealt with as a blanket law. Certainly not a law from Congress when it involves things Congress is not authorized to regulate. So I'm kind of in a quandary here. Yes, I believe 922G is unconstitutional, especially the way it's been applied. But it wasn't found unconstitutional. It was found in violation of the Supreme Court opinion. Which means if another court comes up and says, well, it doesn't quite apply to Bruin, or they can use Bruin's test to say, yeah, it's constitutional, we're not done yet. We have to wait and see. It's one of the reasons why I say it's important we read instead of the Constitution, and that we look at the facts and details before we make judgments. Everybody would like a quick and easy answer. Is it constitutional to permanently remove someone's rights? Well, that is not a quick and simple answer. It depends, which is why I think it should be left up probably to a jury. Maybe a judge, but I would think a jury would be a better solution. Now, I'm curious what you think. These are the type of questions I love getting here at the website, I love getting on my social media, and yes, I love on the radio program. If you want to catch the radio program, it's on AmericaOutloud.news. Just search for the Constitution Study, you'll find it. I also hope you keep up with the website. I've added several mailing lists over the past few months. You can get my daily news updates, you can get my insider updates, and hey, maybe you even want to check out the Patriots program. It's all there at constitutionstudy.com. I hope this particular case made you think. I hope it caught your interest, at least enough to bring you back next time to the Constitution Study.